sense, but
Morning, Mr. Martinez. You have a very common name, and there are a gajillion Francisco Martinezes out there. There's an unfortunately, there is someone wanted in that jurisdiction that has your name, and you see now that you've been...
Let's pause right here. This is one of those nightmare scenarios most people never think about. Being arrested because someone else shares your name. In large databases, law enforcement often confirms identity through name and date of birth first. If both match, that's enough to detain. The scary part isn't the mistake, it's how easily it can repeat unless you take proactive steps. Imagine living with the fear that a traffic stop could turn into handcuffs every time.
Wrongly arrested, you're going to be released today. The fear is that this continues to happen. So I don't know, there are methods out there, and Mr. Kim, you say there's a letter that he can get.
yes.
What we're going to do is, I cannot give you legal advice, but I'm going to have your lawyer that we've appointed to represent you tell you how you can take care of this so that it doesn't happen again. So we're going to process you out. You should be out within hopefully the next 4 to 6 hours. Ricardo will tell you how to go about getting a letter so that this doesn't happen again. Do you have any questions? Did you want to add anything, Ricardo?
It's fair to say, Judge, it's just a bad situation. This man
dificultoso decidir que este señor puede estar preso y no es mío.
Yeah.
it's not a good situation.
Yeah, I mean, mistakes have been made, and I don't know, I guess the arresting officer, I don't understand why they wouldn't do just a little bit deeper dive.
Well, when they're on the...
This is a pure systems problem. Teletypes can't transmit images, no mugshots, no fingerprint scans in real time, just text. So officers are relying on name and date of birth only. That's a massive limitation in 2025. Nobody here is acting maliciously, but outdated tech can still create very real consequences. And that's where bureaucracy collides with real life.
field, and it's obviously an arrest in the evening, is us being one of the few agencies that's truly 24/7, is that they can only confirm by teletype for whatever the fugitive division is. And so with it, it's most commonly name and date of birth, but statistically that should narrow it down, but it's just,
I mean,
because you can't take photos, or you can't
they
send
have mobile apices?
for that when they get processed in, but that only brings them in for, again, the same name and date of birth, but you can't trade mugshots with the demanding jurisdiction. Because the teletypes can't support images. And so ultimately it's only what the text is, and that text is the name and date of birth. So
In all that sense, Judge, would his fingerprint goes with
That's what and that's why I was, they've got these mobile apices that,
the mobile thing where they could just test him and see if it's his prints or not.
sure, but the majority of warrants, the way they're sent by teletype, again, a thumbprint can't be imaged in a teletype.
I got you.
So yes, there is a thumbprint, but there's no way
the
to...
thumbprint should be able to verify who this person is, whether they have the correct date of birth.
But
Mugshots.
that only corresponds to the warrant for the demanding jurisdiction if they have something to match it against. So that's the issue, is yes, it can pull it up on our side, but it's the same way even for our parole violation.
And now everything changes. We just went from mistaken identity to alleged escalation. The moment someone gives a false name and runs, prosecutors start stacking intent-based charges. Intent to evade, intent to obstruct. And when there's already a violent charge in the background, judges start thinking public safety first, second chances later. This is the turning point.
Is they can't check on scene, especially at 1 a.m. That's why we're the second check, is that we're able to verify if there's a thumbprint, mugshot, etc.
You're going to be released here momentarily. I'll have Ricardo tell you how to take the next steps, though, okay? All right, good luck, Mr. Martinez. Thank you.
I think we still need a person, a different one from Mr. Diaz.
That he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop.
I'm sorry, pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on him.
Pause right here. This isn't just a traffic stop anymore. This already crossed into felony territory the second he ran and gave a fake name. Lying about your identity plus fleeing turns a small problem into a life-altering one real fast. And here's the wild part. Every choice after that just keeps stacking charges like a snowball rolling downhill. So ask yourself, if you're already on bond for violent crime, why would you gamble even harder? Because this isn't confidence. This is someone who genuinely believes consequences don't apply to them.
Sir, you were charged with evading arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On January 31st, 2020.
That right there is the probable cause finding. And this is important. Probable cause does not mean guilty. It simply means there's enough evidence to move forward. It's a low legal threshold, but it's powerful. Once that box is checked, the hearing shifts from, "Did this happen?" to, "How risky is this person while we sort it out?" That's where bond becomes everything.
County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
Listen closely to the judge's wording, extreme danger. That language isn't dramatic. It's strategic. Judges are legally required to consider flight risk and community safety when setting bond. Alleged aggravated robbery with a firearm, followed by a high-speed chase at up to 115 miles per hour while already on bond? That creates a pattern. And in bond court, patterns speak louder than promises.
So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, a Kendrick Rashard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024 did then and there unlawfully while in the course of committing a theft of property owned by yada 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 with intent to obtain and maintain control, intentionally and knowingly caused bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle
Yes,
the
sir.
day after our two cases. How? Oh, I guess that's how they caught up to him, right?
That's when
They
they
must
caught up
have.
to him, they found him, and that's when they arrested him on that, and then got picked up on me, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he?
Yes, Judge. It says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
This is a massive moment most people miss. When a judge starts talking about dangerousness, they're not being dramatic. They're legally laying the groundwork to justify high bond or no bond. Translation? The court is no longer treating him like a reckless kid. They're treating him like a public safety threat. And once that label sticks, everything changes. Bond goes up, sympathy goes down, and the leash gets real short. So pay attention, because the tone of this hearing just shifted.
Okay. I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to be with me today, promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one.
Here's the real tension. The defense tried to humanize him, family ties, employment, a sick grandfather. And those factors absolutely matter in many cases. But mitigation only works when the judge believes supervision will control the risk. Once someone is labeled both a flight risk and a danger to the public, PR bond almost never happens. So what do you think? Is this someone spiraling out of control or someone making calculated choices? Let me know below.
I'm making his bonds high, you know. I'm going to set them at $20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
you, Judge.
I don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. He's 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builder's First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but and I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
So I guess the felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond finish with Felicia, and then after that, it's pretty done. Okay.
Can we excuse?
Yes, ma'am. And thank you for everything.
Here's the brutal reality. Judges don't just look at charges, they look at patterns. Running from police, using fake names, violent felonies, high-speed chases. That paints a picture. And that picture says, if I release this person, someone could get seriously hurt. That's why PR bond isn't even a real option here. So let me ask you, do you think this guy is capable of changing, or has he already locked himself into the prison pipeline?